You are on bond for murder, and you've now picked up an assault case.
Right off the bat, you can sense the tension. This courtroom's juggling multiple serious cases back to back. Notice how the judge calmly resets the schedule? That's because the system often moves slower than people expect, especially when DNA evidence or CPS involvement is pending. Justice moves, but it moves carefully.
You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Thank you, Your Honor. On April 27th, 2025, in Harris County, Texas, officers were dispatched to a disturbance/unknown weapon call. The complaining witness stated she is part of the nursing staff and that the defendant has been asked to leave on multiple occasions and refuses to do so. The complaining witness stated that the defendant was attempting to get her grandfather to sign over power of attorney to her, but the staff would not allow this due to the grandfather being diagnosed with dementia. The complaining witness stated that the defendant used force on the complaining witness to get her to leave the grandfather's room. The complaining witness states that the defendant put her hands on the complaining witness's face and pushed it back. The defendant was positively identified by the complaining witness and her Texas ID number.
You say that there was any pain? She pushed in the face. This is an assault, right? There has to be some kind of injury or pain.
She did state that she felt pain in the dim summary.
Okay. Ms. Taylor, I'm going to find that there's sufficient probable cause to go forward with the case. Now, you're saying there's a bond violation in this case?
Yes, Judge, it's in the.
Michael, have you seen this? And how did you already get appointed to this case?
Your Honor, I was appointed sometime very recently on this case. I received a text. I don't know what day it was, but I received
It looks like it was the 29th, which was Tuesday. But how was he appointed a lawyer?
I'm thinking when she was in the holdover.
No. How is she, I mean, I don't understand. Well, regardless, I guess I'm glad that you're appointed because right now she's got bond violations. She was ordered by the magistrate.
I wasn't aware of that, Judge.
I'm sorry?
I wasn't aware of a BVR in this case. I actually have another BVR today before the court.
I know that. Yeah, we got you. We'll deal with that one next, but you're on bond for murder. You were ordered by the magistrate to have a GPS monitor. You have violated those conditions. Unacceptable. I'm revoking your bond. She goes with you. No.
Your Honor, if I may.
Yeah.
Your Honor, she just was released because I met her in the holdover earlier this week, and she could not have been out of jail more than a day, two at the most. Would the court allow her to leave right now to get the device?
No. Did she not get the device?
Judge, there was a conflict, that's why the DVR was submitted, felony, so the magistrate ordered bond conditions, but the curfew times were not aligning with the felony condition.
So what? I mean,
This is the pivotal moment. The defendant's being offered a 5-year deferred probation, meaning if he completes it cleanly, no felony on record. But if he rejects it, he risks up to 20 years in prison. What would you do? Take the deal and move on, or roll the dice in front of a jury? Let me know in the comments, because this decision could change a man's life forever.
you still have to abide by the conditions. I mean, what did they say the conditions were?
I have the paper up right there.
I'm not asking you to say anything, Ms. Taylor. The only thing I want is I want my city protected. You're on bond for this serious case, and now you picked up an assault. I mean, you were ordered to have certain conditions. You must abide by these conditions.
And Your Honor,
She received conditions of bond on April 28, 2025 that ordered a GPS device with a curfew of 7 p.m. to 7 a.m. On May 1st, she had an unapproved enter at 7:52 p.m. and then left again at 8:51 until basically 9 o'clock at night.
Yes, Judge, and on the felony conditions, I'm looking at them right now, their curfew is from 12 a.m. to 6 a.m. So that's where it's conflicting. So the magistrate ordered from 7 p.m. to 7 a.m. and on felony, their curfew was 12 a.m. to 6 a.m.
I mean, she still has to follow conditions, right? There may be conflicting, but, you abide by the conditions and then you come to court and you ask to, do something or maybe make them align, but you just don't do whatever you want to do and think, okay, nothing's going to happen. You're on bond for 2 serious cases.
Your Honor, if I may again,
Sure.
this is a brand new case. Could the court admonish her? Because the amount of time, I understand that.
Michael, she's on bond for murder. She's lucky to even have a bond, and now she picks up an assault. She's ordered to have a curfew, and she's just doing whatever the hell she wants to do.
In this case, Judge, that's before your court. This is a brand new case, and this is her first time having any issues while on your bond, Judge. Would the court be willing to admonish her not to leave her home even for short periods of time?
I don't know, Mikey. I don't know.
And my assumption is we're gonna reach out to felony. My assumption is there's BDR valve for that too, so I don't know what the thought of her looks like, but.
I don't know, Michael. I'm going to stew on it for a while. You
Yes,
want to
Your
talk about your other BVR? Or wait, hold on a second. Sorry, let me just finish with the arraignments. Give me 2 seconds and then we're
Honor.
almost
No
done.
problem, Judge.
Good morning, Mr. Randolph. Good morning. So you're charged with assault, causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. All right.
The judge. Judge on.
We're doing here. There's no reason for you to be looking out there. We're going to do probable cause. We have to find out what happened with the case.
Judge, on April 23rd, 2025, an officer was dispatched from an assault call and made contact with the complaining witness, and the defendant. The complaining witness stated that he saw the defendant talking to and following a witness, and the witness then started to run away and observed the defendant to chase after the witness. The complaining witness then got in between the defendant and the complaining witness, and the defendant then struck the complaining witness with a closed fist. The complaining witness said he felt pain and then grabbed the defendant, and they proceeded to grapple until security arrived. The witness stated that she did not know the defendant and that her and her friend walked past the defendant on the street. The defendant then began to verbally harass them and started to get verbally aggressive. She asked the defendant to leave them alone, and the defendant continued to refuse to do so, and that she began to walk away and to try and get away from the defendant, but got stuck at the intersection crosswalk. Then corroborated the facts that the complaining witness provided about getting in between the two of them.
Mr. Randolph, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand? I'm ordering you also now not to be in possession of weapons, not to have any contact with the complaining witness, and not to go to this part of the street. Do you understand?
Yeah.
Don't be a danger to my city, man. I'm not asking for much.
I'm not in danger. I didn't never know these people, Your Honor. I wasn't out. I need a public defender.
I'll give you one. But I'm telling you now, Mr. Randolph, don't be a danger to my city.
I was never in danger. Just I don't intend to be in danger either.
All I want my streets safe.
They was in danger to me, and that's why I'm showing up today.
I'm going to protect my streets at all costs.
You can feel a rare human moment here. The judge acknowledges this was driven by emotion, not malice. In courtrooms like this, that empathy can make all the difference between redemption and ruin. It's a reminder. Sometimes the law isn't just about punishment. It's about giving people one last chance to prove they can do better.
You
Thank you. Can you
understand?
protect me from these kind of people?
I'm going to have you go to Victoria, sign a reset. After that, I'm
I
going
do
to
need
have
a public defending office, your judge or
I already
lawyer.
told you I was going to give you one. Just really.
I'm really scared for my life because I just did 4 years and I'm going through the same thing again in your courtroom when I did good and I'm going through all the facilities. There was never in a harm's way standing 100 feet away from these people or 200 feet. I was never 100 feet within there.
Go. Exercise.
And I'm
the right
running from
to
these
stop.
people.
You're going to say something that hurts your case. Just stop.
Yes, sir.
I'm not asking you to say anything. I just want,
I just want to also be safe in your community also.
don't use any dope. Don't use any alcohol.
Never was. I was sober that day. I was sober as can be, no drugs, nothing. Enjoying a beautiful day for my mama's funeral. I don't know these people.
Listen, just I'm going to have you sign a reset. I'm going to have you take your seat in the jury. Yo, I'm not talking to you. Once you sign the reset, just take a seat in the jury box. I'm going to find your lawyer, but we need you to sign conditions. Don't leave until you sign the bond conditions.
Yeah.
Come on. You are on bond for criminal mischief. You've now picked up a new case. You now stand charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
The judge. On April 26, 2025, a law enforcement officer is on patrol and observed a motor vehicle run a red light and make a U-turn, nearly striking another vehicle in Harris County, Texas. Law enforcement officer observed the motor vehicle drive onto the curb of Richmond Avenue and initiated a traffic stop. The defendant passed multiple open parking lots and continued to drive. The defendant eventually pulled into a business parking lot. The law enforcement officer contacted the defendant and observed him to be eating fried chicken. The law enforcement officer asked the defendant why he didn't lower the window, and the defendant stated he didn't have any food and continued to eat. The law enforcement officer observed the defendant did not have a driver's license and was incoherent when asked to provide his name and date of birth. Law enforcement eventually identified the defendant by name and date of birth. The defendant continued to state, "I don't have anything on question about his whereabouts," and standardized field sobriety tests were conducted. The officer observed 2 out of 6 clues in the HGN, 5 out of 8 on the walk and turn, and 0 out of 4 on the one-leg stand. Due to the defendant, 0 out of 4 on the one-leg stand due to the defendant being unable to perform the test. The law enforcement officer noted that on the walk and turn, the defendant did not turn around. He stayed still for approximately 30 seconds. The law enforcement officer explained the one-leg stand, and after the instructions, the defendant began performing the walk. This occurrence happened again after the law enforcement officer tried to explain the one-leg stand another time. The law enforcement officer observed 2 unopened 6-packs of alcoholic beverages that were cold to the touch, and observed an empty fuzzball, and a 24-ounce can of Modelo beer, and an empty Twisted Tea alcoholic beverage. The defendant refused both breath and blood. A blood warrant was signed and executed.
Mr. Juarez, I'm going to find that there's enough probable cause to go forward with your case. You said he doesn't have a license, right?
There's a number here, Your Honor. I'm not unsure if that meant that he did not have the license at the time.
Mind running it, please?
Yes, Judge. Your Honor, he does have an eligible driver's license.
I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I've ordered you not to pick up any new cases, not to violate conditions of bond, and you have repeatedly done that. As a result, I am now revoking your bond on the first case, and you will go to jail today. And I'm going to tell you, you violate conditions again, I'm going to make the bond so high your head will be spinning. Do you understand? You're not to consume alcohol or illegal drugs, and I will put a scram on your ankle so I know that you're not consuming. Do you understand?
Your Honor, if I may,
Yes, sir.
on the first case, the court previously was testing Mr. Juarez 2 times a week, and he was doing pretty good on that for an extended period of time. In lieu of revoking his bond, would the court consider going back to biweekly testing?
He picked up a serious case. He has alcohol in the car. I mean, he's allegedly consuming while he's driving, you know? I would figure that it's damn elementary that you're not to have alcohol in the car while you are driving. And there are multiple open containers, cold to the touch. No, I have to show you that we mean business. And me letting you go again when you have multiple violations, it's not going to happen. You go to jail. I don't know what we're going to do when he bonds out, Michael, as far as testing now. I don't know. But
I understand, Judge.
I'm going to order him not to drive as well. I mean, he's got alcohol in the, no, it's not going to happen. Good morning.
Judge, I'm approaching on Victor Jesus Rauda Lopez. And he's got a bond violation report, Your Honor.
Page 10.
Is he here?
He's here, Judge. He's in the jury box.
Speak English?
Yes, he does.
Come up. Come up.
Answer yes or no, sir.
Did you get your GPS device?
Oh, yeah.
Okay. I'm revoking your bond. I ordered you to get a GPS device. You didn't get it. Okay, it goes with you. Sorry, Maria. All right. We're going to keep you. The bond right now is, oh God, it's 5,000 now.
I already paid the half.
1,001.
Yeah.
I'll just raise it up 1,001.
6,000.
It's 5,000 now,
Right.
so I'll just do 6,001.
Okay, Judge. 6,000.
So if he bonds out.
Yes, Judge.
All right, good morning, Mr. Ayler. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. It looks like you're also charged with unlawful carrying of a weapon. On that one, you're facing up to a year and or a $4,000 fine. Okay.
Thank you, Your Honor. On April 27, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle traveling 50 miles per hour in a 30 mile per hour zone via radar and failed to signal at a right turn. A traffic stop was initiated, and upon contact with the defendant, the law enforcement officer observed a handgun on the rear right passenger floorboard, unholstered and later confirmed to be loaded. Law enforcement officer observed glossy eyes, strong odor of alcoholic beverage, and slurred speech from the defendant. The defendant admitted to consuming 3 alcoholic beverages. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, a 2 out of 8 on the walk and turn, and a 2 out of 4 on the one-leg stand. The defendant consented to provide breath and blew a .136 and a .141.
Okay. Any prior DWIs?
Yes, Your Honor, out of a different county.
Is it open?
No, Your Honor, it was closed in 2014 with 12 months of probation.
Can you run a full NCIC to see how many there are?
Yes, Judge.
Mr. Ayler, I'm going to find that there's sufficient probable cause to go forward with the case. Also, if you can run his license, please. I'm now placing a restriction on you, Mr. Ayler. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I will revoke your bond, put you in jail. No more PR bonds. Likewise, you're ordered not to consume alcohol or illegal drugs. You will be randomly tested. I'm sending notice to DPS in Austin. Every single officer in the state will know that if you're driving a vehicle and it doesn't have an interlock, you will be arrested and put into jail. Do you understand?
Judge, it's just the one previous DWI.
Okay, license, what'd you say?
License.
You're also not allowed to drive unless you have a valid license and liability insurance in your name as well. That is a part of your bond conditions. For now, I'm going to have you go to Victoria, sign a reset. You will eventually get with Roxanne for your bond conditions, and after that, you'll be free to go.
It is eligible.
Great. Okay, come on. Mr. Bustamante, I know that there are 2 sides to the story. I get it, right? That's why we have trials. But in the interim, we ask you to do several things. And when you don't, there are serious consequences. Number one, we ask you to show up. On your first case, you failed to appear just in and of itself, and we had to issue a warrant for your failure. We issued bond conditions on that as well. Those conditions were also broken. You've now picked up a new case. I want you to understand something and listen and hear me clearly. Mr. Bustamante, I want you to listen and I want you to hear me clearly, because what I'm doing now is I'm putting orders of protection on both of your cases. And if you violate these, you are looking at 2 more very serious violation of a protective order case. That in and of itself is the capital murder of misdemeanors. Do you understand? You violate conditions on that, I can have a hearing to hold you at no bond.
I understand 100%, sir, Your Honor.
The only thing I am asking you to do is do not have contact with either of the complaining witnesses in these cases. I don't care if they're relation. I don't care if there's no relation. I don't care who they are. Do not have contact. And when I mean no contact, I mean no contact of any kind. No phone calls, text messages, social media, emails, Snapchat, whatever, maybe smoke signals. No means no.
It's a problem, Your Honor. It's not a problem.
So this is now an order that identifies both Bustamantes as protected individuals. You cannot communicate with them. You cannot commit an assault, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, communicate with a third party to try to communicate with them. You cannot be in possession of a weapon or go within 200 feet of where they live or where they work.
I understand, Your Honor. I got 7 kids, and those are not the oldest ones. I'm a good daddy.
Don't talk to these 2.
I understand, Your Honor.
This order only applies to these 2. Don't use the other kids to try to have contact with these. If you do,
We all live together. Right.
now you don't.
Right. I'll go to Mom's house.
Best go somewhere else, because they're going to inform those kids now that you're not supposed to be there or have contact with them.
That's not a problem, Your Honor.
All right.
The first one, my daughter, she doesn't live here. She ran away with her husband. Whenever she called the cops, she wasn't even at the house.
I don't
Understand?
Don't go into
you
the
have contact with them. I'm not asking you much. You've already picked up 2 cases. You pick up a third, I'm going to blow a gasket.
That's the problem. You got it.
State, is there anything else?
Yes, Your Honor. There are allegations of drug use too. We would ask for reading your analysis.
Okay. You're not to use alcohol, illegal drugs. I'm going to randomly test you. If I find that you're using, likewise, I'm going to revoke these bonds and we'll put you back in. As it stands now, you are a flight risk. I'm not going to give you a PR bond. So what'll happen now is we're going to put you back. I've got your bond set. If you have someone that posts your bond, then you must abide by these conditions.
My daughter, my daughter.
I've given you a lawyer. You need to talk to the lawyer. You have the right to remain silent. Everything you say, they're going to sit there and they're going to type it to use it to prove your guilt. Just don't say anything. I'm telling you what the expectation is. So if you do get out, you don't pick up a third case.
I have a question.
What's the question?
Ask the lawyer.
Okay, so, okay.
Okay.
We're good, Judge.
You good? Okay. All right, Mr. Bustamante, you know what's expected of you from now on. That's it.
Thank
Okay, so we need him to sign conditions
Yes,
with
sir.
Roxanne whenever she's ready.
You come up here so I can.
I'm not equivalent. I want to go.
Please.
I want to go to jail.
Good morning, Mr. Godine.
You don't, sir.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
Thank you, Your Honor. On April 26, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle run a red light and initiated a traffic stop. The law enforcement officer made contact with the defendant, the driver, and observed bloodshot eyes, droopy eyelids, constricted pupils, unbalanced, and the defendant to be talkative and have trouble concentrating. The defendant admitted to running the red light. Standard field sobriety tests were conducted. A 2 out of 6 was reported on the HGN, a 5 out of 8 on the walk and turn, and a 1 out of 4 on the one-leg stand. The defendant estimated 30 seconds passing in what was in reality 72 seconds on the one-leg stand. The defendant admitted to smoking weed earlier. The defendant consented to breath and blew a .00. The defendant consented to drug influence evaluation, and a drug recognition expert believed the defendant to be under the influence of a central nervous system stimulant, a narcotic, an analgesic, and cannabis. Thank you, Your Honor. And the defendant admitted he took oxycodone or narcos and smoked weed. A blood warrant was obtained and executed.
Mr. Godin, I'm going to find that there's sufficient probable cause to go forward with the case. If you have a drug or alcohol problem, now is the time for you to address it. I'm giving you the opportunity now. If I find that becomes a problem while you're on bond, I'm going to revoke your bond. I will put you in jail, and I'm going to address it myself. Oxy is one of the absolute worst things that you could possibly take because you build up such a tolerance to it. You literally put your lungs to sleep if you take too much and you end up dying. I cannot tell you how many people have died from this drug. It's absolutely disgusting. And the maker has been sued repeatedly by how many different states in this country because it's such an addictive thing. Don't use. I'm telling you now, within the next week, I'm going to test you because I want to make sure you're not using. Do you understand?
Sir.
Don't use. You've got a great lawyer here. She will take care of you, but I don't care who you have here. Jesus, you use. It's not going to go well. Do you understand?
Yes, sir.
License, prior DWIs?
The license is eligible,
Okay.
and not seeing any prior DWIs here, Your Honor.
I'm telling you that I've had probably a handful of friends that have died from Oxy because they continue to take it, build up that tolerance, and put their lungs to sleep. It's disgusting. Just don't. Do you understand?
Yes, sir.
I don't want you to kill yourself. Life is way too short.
Yes, sir.
You're not allowed to drive unless you also have a valid Texas driver license and liability insurance. Do you understand? Because you have a lawyer, we will waive your appearance, but it is your responsibility to stay in touch with Ms. Barks, and she'll tell you if and when you have to come back to court. Be careful. Don't use. As long as you do, all is well. Come on.